Sarah Boone had a protracted and extended wait for trial because she and her attorneys did not necessarily see eye to eye. They were state-appointed lawyers. I think there was a disconnect between her expectations and what her attorneys would and should actually do. Sarah Boone did not believe that her attorneys were focused enough on her and her case. And from going through the trial and watching the police interview, it seemed very much that Sarah Boone was like, I am entitled to your full and undivided attention. And if you don't agree with me, it's because you are wrong. I am not wrong. What I appreciate about Sarah Boone is that when she does not get her way, she does tell us how she really feels. She had a full fucking crash out after sentencing. She was convicted of the second-degree murder of her partner. She zipped him into a suitcase. She said she was just playing. She left him there in the morning. Well, he was no longer alive. She video recorded herself taunting him. It was horrific and disgusting and chilling. The case against her was quite strong. She wanted to run a battered spouse defense, or a battered, as they called it in Florida, a battered woman's defense. But the jury was like, no, that's not happening, which doesn't discount that there was violence between Sarah Boone and George. But the jury finding said squarely to me that at that time, Sarah Boone was not in danger from George. She was offered a pretty beneficial plea deal, denied that plea deal, and was sentenced to life, period. Sarah Boone is now trying to appeal. Her initial defense attorney, who parachuted into the case, very confusingly filed the appeal in a circuit that doesn't exist in Florida. I think it was probably a typo. 2 appellate attorneys were appointed. The first one was appointed and either conflicted or could not take the case or what have you. The second appellate attorney was appointed in December of 2024. Sarah Boone filed a letter that we covered just a few days ago. And when she filed that letter, we went over her filing saying, my attorney's not contacting me. And wildly, I have all of these friends that are contacting this attorney every single day, and the attorney's not calling them back. First of all, attorneys can't discuss your case with anyone but you. Second of all, I'm sure the attorney is thrilled that their email and voicemail or whatever is getting blown up a million times a day by people on behalf of Sarah Boone. I also think that people should be kept in the loop about their cases. I am not sure that that hasn't been done here. The thing is, with appellate cases, it takes a long time because it took, in this case, quite a substantial amount of time to get the transcripts. And an appellate attorney can't do anything until they get the transcripts. So you can't really file an appellate brief until you have the transcripts. And the transcripts in this case took a while. So the attorney, by way of an update, has filed a notice of extension July 1st. The motion for extension of time is granted. The appellant shall serve initial brief within 60 days from the date of this order. So 60 days from July 1st, the appellate brief is due. On the 8th of July, Sarah Boone filed her notice to the court saying, excuse me, Your Honor, you appointed counsel December 18th, 2024, and court-appointed counsel Joshua E. Adams has sent a single basic introduction via inmate messaging on February 27th, 2025, asking if she had any information and to not hesitate to contact him with. And he has not contacted her in 7 months. Appellant respectfully requests this honorable court to please advise, which the court can't do. The court can't tell Sarah Boone what to do. Please advise and take notice of these violations and either compel court-appointed appellate attorney Joshua E. Adams to fulfill his legal duties and communicate immediately, or appoint new counsel capable of necessary communication and representation and inclusion of the appellant. She filed that on July 8th. And on July 28th, the attorney filed a motion with the court. July 28th, 2025. Motion to withdraw and request for appointment of new appellate counsel. Okay, Sarah, you wanted new counsel? Have new counsel. Here you go. Comes now undersigned court-appointed conflict counsel for the appellant and pursuant to the Florida rules, respectfully moves to withdraw as counsel and requests that new counsel be appointed. In support, counsel states, appointment and procedural posture. The appellant Sarah Boone was convicted in the Circuit Criminal Court and subsequently filed a notice of appeal. Yeah, Owens filed it in the wrong court. The undersigned was appointed by the lower tribunal, which the trial court, not the appellate court, that's what they mean by lower tribunal, the trial court, as conflict counsel after conviction to handle the appellant's appeal pursuant to Chapter 27 Florida statutes. A notice of appeal has been filed and the undersigned has complied with the appellate rules by filing the necessary statement of judicial acts, directions to the clerk, and transcript designations. Good cause for withdrawal. The rule provides that trial counsel may not be relieved of duties except with approval of the lower tribunal as good cause shown. This is not trial counsel though, so I'm kind of confused why it's trial counsel, but that's what he said. The undersigned is no longer practicing appellate work or accepting court-appointed appellate cases, which would make continued representation a hardship. Continuing to represent the appellant on appeal would materially impair counsel's ability to provide effective assistance and would delay or jeopardize the appellant's appellate rights. You've already been appointed this case. If you change your practice and are no longer practicing in appellate work, you took this case in December. So have you not been working on this case already? Also, you say you're no longer accepting court-appointed appellate cases. You accepted this in December 2024. This rubs me a bit the wrong way. I understand that Sarah Boone is not an easy client, but it's an appeals case. There's not much you need from the client. Also, you can talk to counsel because she was not representing herself. You can talk to counsel Owens and ask him. And you've got the transcripts. The appeal is based on the transcripts. He is not saying that the relationship has become untenable. He is not saying that he has an unresolvable conflict. He is saying, I don't do appellate work anymore. And I'm not accepting court-appointed work anymore, but you did accept this case. It's an interesting conundrum because you're no longer accepting cases doesn't mean you can't finish out the cases that you have. It's a very odd way to ask for withdrawal for me. I have so many more questions about this, and I wonder if the court will have more questions too, because he almost missed a window to file appeals. There might be other things going on. Normally, though, those would be disclosed to the court. Most attorneys, once they've been appointed without good cause, will continue along in a case. And good cause is not, I'm not taking cases now, because this case was taken in December 2024. And I imagine he's already been paid or at least billed for the work that's been done, because work has been done. If there were personal reasons that the case could not continue, that would generally be noted. If the attorney was unable to practice for health reasons, that would be noted. If the attorney was unable to work with the client or the client had made statements that made it a conflict for the attorney to continue, that would be stated in that way. This is an odd one, and I could see the court saying no. Also, when was the decision made to no longer accept work? Why could this not have been filed sooner? This is an odd thing. Because this is a publicly funded appeal, the appellant is entitled to continued assistance of counsel. Rule 9.140D directs that in publicly funded appeals, the lower tribunal should appoint the public defender or the Office of the Criminal Conflict and Civil Regional Counsel or private registry counsel to represent the defendant on appeal rules. The undersigned therefore requests the court enter an order relieving current counsel of record and appointing appropriate successor counsel. This is going to Judge K. So Judge K is the one who's going to have to decide this. There is something amiss. I don't know what it is. We don't have enough information. But the I no longer practice this and I don't take cases now is not going to be good cause. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.